Hi everyone, I want to talk today about the 3 mistakes that parents typically make when leaving money for their kids. Hi, my name is Eric Scruwala, and I want to leave a legacy, a financial legacy for my children, and I assume you do as well. But the 3 mistakes you need to avoid. Now, number one is doing nothing at all and just hoping that the money ultimately gets to them. But there are two problems with that. Number one is that if you have kids, once kids turn 18, they get money outright and they may not be equipped to handle it. But even worse than that, if they're not 18, then their money goes under the protection of a court-appointed conservator who will be paid to manage that money for them and could eat up a substantial portion of the legacy you've left for them in fees. Now, second mistake is that when people actually sit down to make a plan and put money in trust for their kids, they don't really think about who they want to have to manage that money for them. And so really taking the time to consider appropriate trustees of that money for your kids is really important. Equally important is to identify people who can step in if the first person you've chosen isn't able to or is somehow incapacitated. So always making sure that you have somebody who can stand in and take care of the property you want to leave behind for your kids. Absolutely critically important. And number three is that a lot of people don't realize that if you have life insurance or you have retirement accounts such as a 401k or an individual retirement account or IRA, that those assets pass to children through what's called a beneficiary designation form. Now, that form is something you file with a financial institution, and whatever you might have in a will or a trust or other planning document you've created has no bearing as to how those monies will be distributed. Now, if you've identified or if you've left that money to kids outright in those beneficiary designations, then you could create the problem that we identified by doing nothing, which is that if it's in their name individually, whether you have other planning documents or not, a court would appoint a conservator to manage that money on behalf of your kids at the expense of you and ultimately their expense. So if you do establish a trust, and I highly recommend you do, then what you want to do is to change those beneficiary designations to name the trust as the beneficiary of those assets. If you have any questions about this or want to talk further about how your plan may impact your children's future, feel free to shoot us an email, leave a comment below. We'd be happy to help you out. Until next time, take care. Bye.